Good morning and welcome at the lecture on Reform in Criminal Law, the Need and Way Forward for Honourable Members of Parliament, which has been organized by the Parliamentary Research and Training Institute for Democracies. This lecture is in a hybrid mode, wherein we have sent the link to the state legislatures also for Honourable Members of Legislative Assemblies and also for officers, and we have also shared the link with the embassies. Today, as we know that the Committee for Reforms in Criminal Laws was set up by the Ministry of Home Affairs, Government of India, to resolve issues in a principled manner that balances the positive obligations of the state with the rights of the individual and the community. An extensive consultation on substantive and procedural criminal law and evidence were sought from the stakeholders for amendments to the Indian Penal Code, IPC, and the Code for Criminal Procedure, CRPC, and the Indian Evidence Act. The program will include discussion to increase awareness, enable constructive debate and consultation among the honourable members and other stakeholders. To speak on the subject, we have with us Professor Shri Krishna Dev Rao, who is Vice Chancellor of National Law University, Delhi, and Chairperson Committee for Reforms in Criminal Laws. Professor Shri Krishna Dev Rao is an eminent teacher and scholar in criminal law and SS2 justice. And Professor Rao had the distinction of working with 5 prestigious law universities of India in the past 3 decades. He has been in National Law School of India, University, Bangalore, Nalsar, Hyderabad, Gujarat National Law University, Gandhinagar, National Law University, Delhi, and National Law University, Odisha. He was also member of the National Legal Services Authority. He was also invited to be a visiting fellow at the University of Washington and also in London, and his major areas of research are in criminal law and criminal justice administration. His close collaboration with research projects of UNDP, Law Commission of India, Ministry of Law and Justice were very significant. Professor Rao also received recently the highest award in the field of criminology, Kumarappa Reckless Award, for his outstanding contribution in criminal justice, and he also received an award, Business Excellence and Innovative Best Practices, Academia Award 2021. So with these words, I request sir to address the dignitaries and the participants, and along with him, we also have Shri Neeraj Tiwari, Assistant Professor, National Law University. But before we proceed the session, I will request my Assistant Secretary, Additional Secretary Shri Prasanjit Singh Ji, Lok Sabha Secretariat, to say a few words.
On behalf of Team Pride, it is my proud privilege to extend a very warm welcome to the honourable members of the Parliament who have joined online, and the honourable members of the state legislatures and the officials. And I also welcome Professor Rao and Shri Tiwari for accepting our request for addressing the session. Now I will request Professor Rao to kindly address the gathering. Thank you.
I'm audible, no? Yeah. I am privileged and honored to interact with the distinguished members of the Parliament on the invitation of the Pride Lok Sabha Secretariat. I am also grateful to 2 of my mentors, eminent criminal law teachers in India, late Professor N.R. Madhavamenan, who introduced me to the different facets of the criminal justice in India. And these ideas and thoughts were sharpened with the interaction and learning with Professor B.B. Pandey. And this is a culmination of the over 3 decades of my interest in the criminal law. Let me begin with 7 core issues for the today's discussion. The first slide, please. The first issue is, what are the aims of, second slide. What are the aims of criminal laws? Second issue is challenge of balancing the twin tasks in the criminal justice system. Third issue is inheritance of the colonial criminal law legacy. Fourth is the guiding principles for reforms. Fifth is the models of reforms in the criminal laws. Sixth is the constitution-oriented criminal law reforms. And lastly, reforms through the judicial process. Next slide, please. criminal law makes passionate dialogue. In fact, it evokes, because the impact on the freedoms, rights, and liberties of the citizens. If we look at the Constitutional Assembly debates when the founding fathers are in the process of making the Indian Constitution, we all know that there is a dialogue between procedure established by law and the due process of law, and Dr. Ambedkar, one of the architects of the Indian Constitution, introduced Article 22 into the Indian Constitution, which is called as the Bill of Rights of the Accused, as a compromise. Let me begin with the first aim of the criminal law is the striking balance between the prerogative of the state and the liberties of the individual. Second important challenging task is the twin task, the control task of preventing criminal acts and the task of ensuring just and fair procedure adopted by the state in its actions. The control task is of preventing the criminal acts and the task of ensuring just and a fair procedure. And if you look at the control task, is identification of the human behavior that constitutes what is deviance, what is crime, and the appropriate sanctions that are deemed appropriate for serving the control function. The last issue in the aim of the criminal law is the just and fair procedure task, which has witnessed the movement or the emergence from the trial by ordeal, trial by battle, to the most sophisticated fair trial criminal procedure, which are which is a shift from punitive control to preventive control. Next slide, please. The second slide, I will like to throw some light on the challenge of balancing the twin tasks. The control and the fair just procedure tasks are often in conflict with each other due to their inherent conflicting interests. Famous American criminologist Herbert Packer long ago has said about discussing about the criminal justice system in the United States, said there is two types of models, the crime control model and the due process model. And we have seen over 7 decades of the Indian Constitution, over more than 7 decades, these conflicting interests always have come into the forefront. Owing to the criminal justice system, remain perpetually in balancing one against the other. And in this process, the principle of legality, which is the foundational rule of criminal law, which says no act which is not penalized under the law ought to be punished. And principle of legality, presumption of innocence are some indicators of a fair and just procedure. However, the emergence of crime control consideration and efficiency and credibility produced tangible outcomes like larger number of arrests and also the conviction rates, and making the crime control model more suitable to the state's interests. In this process, the important agency of the criminal justice system is the police. Police is an agency which is seen with an increasing role in the criminal justice administration with a control task and also the task of achieving fair and just procedure. And this ensuring and guaranteeing the fair and just procedure is entrusted to the judiciary. The next slide, please. Let's look at, before we move into the other issues, the inheritance of colonial criminal law legacy, which is also very important. The evolution of Indian criminal law can be traced back to the time of the British rulers, establishing effective colonial governance in India in the mid-19th century. We are also take cognizance of Article 372 of the Constitution of India, which mentions that all the laws in force in the territory of India immediately before the commencement of the Constitution shall continue in force therein until altered or repealed or amended by a competent legislative or other competent authority. The British colonial model of criminal laws had become acceptable and credible because it epitomized the best principles of adversarial system of criminal justice. If we look at the colonial legacy of criminal laws, primarily the Indian Penal Code, 1860, the Criminal Procedure Code, 1861, which was revised, amended, 1882 and 1898, the Police Act, 1861, and the Indian Evidence Act, 1872. The colonial criminal laws were enacted mainly to enforce and strengthen colonial administration in India. If you look at briefly, after the post-independence, about 60 sections were amended in the Indian Penal Code. About 5 to 7 times Criminal Procedure Code been amended. 2 to 3 times Indian Evidence Act has been amended. Although enormous gains were made by inheriting ready-made system of criminal justice, and the responsibility for making this criminal justice appropriate for the change time is squarely on the alert criminal law reform institutions like the Parliament. Next slide, please. Let me look at the guiding principles for the reforms. Any reforms introduced must also conform to the principles of constitutionalism, human rights, and the fundamental rights of dignity, privacy, bodily autonomy, and integrity. Over the years, for instance, the law reform task has gained new insights and credible touch with the coming into force of the Constitution of India and the enactment of Protection of Human Rights Act 1993, under which the National Human Rights Commission of India has been established, that have set new criminal law reform goals and directions. Criminal law reform should aim at fine-tuning the criminal justice system in a principled, effective, and efficient manner to ensure safety and security of the individual, community, and the nation, and which also prioritizes the constitutional values of justice, dignity, and the inherent worth of the individuals. Next slide, please. If we look at the models of reforms in criminal laws over the years, we could see 3 main trends which have been reflected. One is the piecemeal model of criminal law reform. Second is the episodic model of criminal law reform. Third is the comprehensive model of criminal law reforms. In addition to that, we also have the several reforms were suggested through the landmark decisions and opinions of the judiciary. Let me begin with the models of the criminal law reforms in India. The reforms in the criminal law have constantly underway. Even during the colonial times, several reforms were made in the post-1860 period in the Penal Code. We could see 1870, 1891, 1913, 1923, and 1925. But we are more concerned about the post-independent India, the process of criminal law reform. We could see the process of criminal law making in the post-independence India. As I said, we can divide or categorize into 3 models. Piecemeal model, where by adding, modifying, or repealing certain provisions, we have observed, and approximately about 60 instances of amendments to the Indian Penal Code we could see in the piecemeal model, and similarly criminal procedure model also we could see 7 times, and 2 to 3 times Indian Evidence Act, because Indian Evidence Act is one of the best evidence act, and over the years the Indian Evidence Act remained constantly untouched. Let's look at the episodic model. We are all aware several times the government of India was instrumental in initiating some amendments due to any of an important episode which shook the nation of India. So episodic model, we could see the amendments in response to a particular crime that triggered national-wide unrest and dissatisfaction with the criminal justice system, whether Nirbhaya case or any other instances we could see as demonstrate the episodic model. The comprehensive model, which is primarily interested in revamping the criminal justice system and recommends setting up bodies for periodic review of criminal laws. We can give an example like the Malimat Committee report, which is the first time suggested a comprehensive reforms, and indirectly we could also mention Justice J.S. Verma Committee report, but that also came because of these episodic model after the post-Nirbhaya case, but Justice Verma Committee also suggested several reforms, and that was instrumental in the new legislation which were passed later. In addition to these three models of the criminal law reform, additionally, over the years, we have seen reforms were introduced to several landmark decisions and opinions of the Indian Supreme Court. Next slide, please. Let's look at briefly about the constitution-oriented criminal procedure reforms. We have seen post-emergency Indian Supreme Court was very effective in thinking about and bringing the constitutionalization into the criminal law paradigm and the debate. What we have seen, the Menaka Gandhi case is very important case. For the first time, it has brought just, fair, and procedure into every interpretation of any laws and procedures in India. So securing in this constitution-oriented criminal procedure code reforms, I would like to briefly outline some measures. The first one is introducing section 436A into the Indian criminal procedure that ensures securing personal liberty of under trials by putting an end to inordinate custody. That was a significant feature which was introduced because we know even now under trials constitute over 70% in the Indian prisons. Second issue is about making bail as a matter of right to every indigent. Again, section 436 in the bailable offences, bail is a matter of right and jail is an exception. The third one is introducing plea bargaining in the matter of sentencing. This is a significant contribution made by Justice Malimat Committee report. For the first time, Justice Malimat Committee has report very comprehensive, introducing American model of plea bargaining into the Indian soil. That the successful efforts have been made, but still it needs to be further fine-tuned because our idea is how do we unburden the criminal justice system? How do we make only the criminal justice system will focus on important cases rather than taking care of the other issues, because that is causing and that is one of the potential factor for the delays in the criminal justice system. Also, the Malimat Committee report for the first time also underscored the importance of the victim in the criminal justice system. It has also advocated for the restorative justice system. So therefore, this is another important issue which is linked to the constitutional-oriented criminal procedure reforms, that is providing victim justice through participation and compensation. Lastly, the major issue is related to the law of arrest, and we have seen some of the landmark cases I'll mention in the next slide, which has brought for the first time rationalization of the arrest powers by introducing due process compliance in section 41, clause 1 and clause B. Next slide, please. This is an outstanding, we could see, as the fourth model of reform suggested by the landmark cases of the Indian Supreme Court. We could devote some time on the reforms through judicial process, the contradictory tension of colonial legacy of command and coercion on the one hand, and the adherence to the new constitutional vision of democratic compliance on the other, has posed several challenges to the constitutional courts in interpreting criminal laws. The fair criminal trial values got reinforced by the Constitution coming into force, and it prescribed the normative basis and legal actionability equality which applies not only to the functionaries but also to the process of criminal justice system. The constitutional courts, through the various landmark decisions, has fulfilled major considerations for enacting the Code of Criminal Procedure Code 1973. If you look at three important considerations of the new Criminal Procedure Code 1973 is speedy disposal, speedy process of compliance, fair deal to the poor sections of the society, fair trial. These are the three important considerations we could see in the new Criminal Procedure Code 1973. Let's look at some of the notable decisions of the Indian Supreme Court. We could look at 1977, 1978. Several landmark decisions were instrumental in bringing the reforms in the judicial process. Let me begin with Muhammad Ghiyasuddin versus State of Andhra Pradesh, 1977. First time the questions were raised. What is the aim and purpose of criminal law? Why do we punish? What is the objective of the punishment? Should we reform? Should we rehabilitate? And that was a major issue raised by Muhammad Ghiyasuddin, which still considered as a direction for the Indian Supreme Court when it comes to the punishment. Second is the Motiram versus State of MP, 1978. That's a landmark case. Even now, when we discuss about jail is a rule, bail is a rule, jail is an exception, that dictum emerged from Justice Krishna Iyer's judgment of Motiram versus State of MP in 1978. That tried to look at remove the monetary surety, monetary bail, particularly in the bailable offences. Bail is a matter of right. As we discussed, Menaka Gandhi case versus Union of India, 1978. That's the first time the constitutional law jurists and critics say that has brought back the due process clause into the Indian criminal justice system, Indian constitution, which was hesitant when the Indian constitution, in the debates of the Constitutional Assembly debates, if you remember, B.N. Rao and Justice Frankfurter's dialogues and discussions, and the initial hesitation to introduce due process clause was brought back through Menaka Gandhi case in 1978. Nandini Shatpathy versus P.L. Danny, 1980, is another landmark case where the right to self-incrimination and several issues were brought. And that was a case where the American landmark Miranda versus Arizona was brought into the Indian soil. And then we have the compensatory jurisprudence, the landmark case of Rudul Shah versus State of Bihar in 1983. And in rationalizing the law of arrest, Joginder Kumar case 1994, D.K. Basu case 1997 were instrumental in the reforms through the judicial process. In this, we can also mention about Navtej Singh Johar case of 2018, Joseph Shine case of 2018, first time has brought spotlight into section 377 and the adultery in the Indian criminal justice system. The last slide is on the reforms through the judicial process. We could look at the landmark, in addition to what we discussed in the earlier slide, some of these reforms were initiated in the judicial process. I broadly categorize three types of reforms. The first one is infusing accountability in the criminal justice machinery. Particularly 2014 is a historical phase in the Indian criminal justice system. Lalit Kumari case versus Government of UP in 2014 questioned about what is the police duty in the FIR, how mandatory registration of FIR must be complied and followed. That was taken up by Arunesh Kumar versus State of Bihar in 2014. Arunesh Kumar has taken further the D.K. Basu directions on providing documentation of arrest, and arrest must be made only when it is necessary. No routine arrest should be made, mechanical arrest should be made. Arunesh Kumar came in the context of the cases related to the women and domestic violence and other issues, but the first time Arunesh Kumar in 2014 has changed even the arrest provision, Section 41 in the Indian Criminal Procedure Code, where they said they have created a distinction between arrest in case of more than 7 years, arrest in case of less than 7 years, and further they have reiterated the D.K. Basu principles and Joginder Kumar principles in documenting the arrest and making that, rationalizing the principle of arrest. Arrest must be made only when it is essential. What we have seen, because of these arrests, there is a more under trials, and that's also creating a lot of problems for the delay in disposal of the criminal justice system. Third case is important, Subramanya Swamy versus CBI in 2014, and Subramanya Swamy raised an important issue in the Prevention of Corruption Act, where he questioned about the separate investigatory mechanism for government's officials above joint secretary rank, and this was later led to amendment to the Prevention of Corruption Act. These are the three important issues in 2014 which raised the issue relating to infusing accountability in the criminal justice machinery. Second set of cases we could see securing the bail justice, Firoz Khan versus Government of NCT Delhi, Delhi High Court, and later on before the Supreme Court in 2020, which again mentioned about the bail, where it said it's not enough if there is no enough evidence to release a person on bail, because the prosecution argued in this case that even though there is not sufficient evidence, but if you release the message to the society that we have not taken serious consideration in case of this releasing a person on bail, but the court did not agree. He said there is a foundational principle. Only when there is a prima facie evidence against a person, he should be arrested. Otherwise, bail has to be as an important consideration the court have to consider. Second issue in 2020 is again related to Kasi versus State 2020, which discussed about the default bail. We know under Section 167 Class 2, if the minimum time, the charge sheet, and which has not been filed, and the accused has a right to have a default bail, and the Supreme Court in this case has clearly mentioned default bail has to be given. Particularly, this is very important, this case came in the COVID times. COVID time, they said, much more vulnerable, so therefore default bail has to be given. The last case in the bail justice is related to Shehbaz Hussain versus State of Rajasthan 2020. This was another case which was primarily based on the assault by the prison officials during search, and they found 11 injuries on the body of this person who has been admitted into the prison, and there was an investigation by the police, but no action was taken. The Supreme Court clearly said, release the person on the bail, detainee on the bail, and ordered an inquiry. Last set of two cases I would like to briefly discuss about the fair trial compliance. Anoki Lal is an excellent case which clearly demonstrates the conflicting, what I said in the initial crime control model and due process model. Justice Uday Lalit delivered this judgment in 2019. This is a case of a rape and murder of 9-year-old girl. And this case came from Madhya Pradesh. The investigation, trial, sentencing was completed in 12 days. So much of expedited the trial. We appreciate, but that was this 12 days the trial, investigation, trial, sentencing was completed. Sessions trial, another 5 days, and then it came before the High Court for imposition of death penalty. Within 3 months, High Court has confirmed the death penalty. When it came an appeal before the Supreme Court, Justice Lalit was shocked. Justice Lalit said, we appreciate, that's what we said, efficiency in the criminal justice system is necessary, but no dilution of the fair trial standards. Justice Lalit said in this case that order de novo trial. So therefore, this is the contradiction within the criminal justice system. speedy efficiency is necessary, but at the same time, some of the foundational principles of the criminal justice has to be followed. Next case is related to the Muhammad Hussain versus Government of NCT Delhi, 2012. This was, we know, of the Red Fort attack of 2012, and the entire case was followed, convicted, and death penalty was given, but no legal aid was provided. And the Supreme Court said, if there is no legal aid is provided, death sentence imposed will vitiate the judgment. And then, in this case, the Supreme Court said, legal aid in criminal, in this case, the Supreme Court said that he should be released. And so that emphasizes how legal aid is important in the criminal justice system. India has a robust the legal aid system in India. The National Legal Service Authority is taking, which is generally is chaired by the senior judge of the Supreme Court, has taken a lot of important issues related to the legal aid. I'll just quote what Justice Uday Lalit, who is now currently the chairperson of the National Legal Service Authority and second in command, who is going to be the next Chief Justice of India. So I'll just quote what Justice Uday Lalit said relating to the legal aid very recently. He said, legal aid in criminal cases constitutes only 1% of total number of cases, and it's even less than 1% in the pre-arrest stage. And if you look at all over the world, the United Nations has come out with a comprehensive guidelines of legal aid. Legal aid should be provided in the police station, which long ago the Indian Supreme Court said in some of the cases, legal aid has to be strengthened in the prison, legal aid has to be provided during the court and also in the post stages of appeal and other. That robust legal aid mechanism is one of the effective way to deal with the pendency, avoid delay. So with these few words on raising some of the critical issues, 7 critical issues, I look forward to any questions or any comments and suggestions. Thank you.
Thank you so much. And now the floor is open for questions or any comments, any queries.
Criminal justice system or anything, it is basically the people who are going to be implementing it. See, if the person is fair, any law will be fair. But if the person who is going to be implementing is not fair, then it can always be abused. So whatever laws and whatever statutes that we bring out, it is left up to the person who is handling it. In fact, we have seen a few cases where these laws have been abused against innocent people. It has been used. In fact, I think some 14 lakh people have been arrested without any cause as of 2001. More than 14 lakh people. So, even if you are detained for a few hours when you have not done anything wrong, I think it is, total loss of freedom. So, is there any mechanism where these kind of perpetrators who have taken law into their own hands are punished? Because there are instances where something's in Tamil Nadu. There was recently a case where a father and son died in jail, and there was a lot of news of that they were brutalized. Very sadly. But what kind of action can be taken against these people where this is not a crime of passion or accidentally? It was something where they intentionally, a group of people, especially police, when they do this, what kind of protection can society expect from these kind of people?
Yeah, that's a good question. I'll go back to 1995, very landmark case, Ram Sagar Yadav versus State of UP, which the first time dealt with these issues. This was a case related to Brijlal, who was a farmer in the Uttar Pradesh, and he has a small petty dispute in the agricultural boundary dispute, and the police constable came to his house and he said, give me 100 rupees, I'll see that no case will be there. And then he gave that money, and later after a week, again the police demanded more money. Then he wrote to the superintendent of police in the districts complaining against this police official. And after that, the police constable came and he was taken to the police custody. Within 2 hours, there's more than 20 multiple injuries on his body. And the police got panic and took him straight to the court hall. This is where Senior Justice Y.V. Chandrachud wrote the judgment, and he mentions that this is what the duty, first time production before the magistrate is a very important stage in prevention of custodial violence, as the case you have mentioned in Tamil Nadu. And here, in this case, the police went to the magistrate court hall, and then the police requested the magistrate, sir, a remand application aap sign karke de dijiye. Generally, we understand the magistrates and the police are also working in a lot of uncomfortable situations. Magistrate has to deal a number of cases. Sometimes what happens, the remand papers are taken to the court hall and the magistrate generally, mechanically, routinely signs the remand papers, not looking at or physically examining the detainee at that time. This is very important, not only now, last 4 or 5 decades the Indian Supreme Court is mentioning. This is the internationally recognized principle of human rights that whenever the first time a person is produced before the court, it is the duty of the court to physically examine and ask any complaints of torture or custodial violence. In this case, Justice Chandrachud mentions in 1995 Supreme Court decision, this magistrate asked the police, where is Brijlal? And the police said Brijlal is in the court veranda, he is unable to come. He goes out of the court hall and he saw Brijlal. Brijlal is just about to die. He records the dying declaration. This is what Justice Chandrachud says. Simple, effective method in prevention of the custodial violence or a torture is where physical exam. That is what we look at. There are several criminal justice agencies, the police, prosecution, magistrate, prison official, probation, correction, all this. But what is the judiciary has a major role, what we call as a watchdog in the criminal justice agency. That's the reason we could see several reforms were initiated by the Indian Supreme Court and the judiciary. So this was a landmark. After this, Justice Chandrachud requested the Law Commission of India to come out with a report on injuries in police custody, and after that the Law Commission of India has come out with the injuries in the police custody, which suggested that presumption of innocence should be, Indian Evidence Act has to be amended, but still it's a long way to go. Yeah.
And the other thing I wanted was, we have hospitals, doctors working round the clock, 24/7, and police also working round the clock. Why is it that the judiciary shouldn't the judiciary also work round the clock? Because when we are talking about lakhs of people being detained, this is a place where the judiciary also should be available at any point in time. When you say that Saturday, Sunday and summer vacation, if there are urgent, and you have, kind of special courts. What I'm saying is, why not make it where the courts will be functioning like hospitals and police stations where it will be 24/7?
I think I appreciate your anxiety and concern, and the current modern judicial work also is, they're working even on Saturdays. And generally, in our interactions with the judiciary, we could see that what we look at a judge is only sitting in the court hall. After that, he has to carry all the files. He has to read. He has to appreciate the evidence, understand, writing the judgment. But there is a change. There is a change. I know that there is a punctuality discipline in the court work. Morning, if a 10 means, there are. Some of them are extraordinary, outstanding. But everywhere there are good people and some of them are still learning. But the discipline in the court hall, timings, and majority of the cases, Saturday they started working. And this is a trend, but please understand the judicial work is not just only sitting in the courthouse.
No, I understand that.
But,
I'm not saying that the
absolutely.
judges are not working or that they are bad.
Yeah.
I'm just saying why should it not be available where law should be available at all times. I mean, 24/7.
Sure.
See, if a police is arresting a person, like if in case somebody has an injury, immediately if he goes to a hospital and if the hospital
Yes.
says Saturday, Sunday, we are not going to be working
Yes.
and we are going to operate only on Monday.
Yes.
It's the same as that.
Absolutely.
If a person is going to be arrested, straight he has to be produced in the court. So that can happen at any point in time. And only after a judge says that, I understand that judge has many work. So increase the number of judges. I'm not saying that they are bad.
Sure.
I'm not saying that they are not working. I know that they have to do so much of research because even in Tamil Nadu, I mean, I've worked with quite a few judges in Tamil Nadu where when they go through a case, it may look trivial.
Yeah.
But the amount of research they have to do to even talk about that, I mean, sometimes it has to be where 100 years of history they have to go through to be able to arrive at a case.
Yes.
I am not denying the fact that some of the judges are fantastic and great. I'm not talking about that. I am saying when hospitals and, the police, all these organizations can work 24/7, shouldn't we have a provision where the legal system also should be available 24/7?
Yeah, no, I think that is already the magistrate is available 24 hours. Generally, in our, what we say is judges have no Sundays, judges have no evenings. Similarly, the police.
They go to their houses. They go to their house and get the thing.
No, absolutely. Journalists.
Yes.
Absolutely. Once you come into the profession, whether it is a doctor or a lawyer or a judge or a journalist, absolutely is no Saturdays, no Sundays. Even in the night they come. And particularly what we have seen, even you have seen sometimes the Supreme Court was opened in the midnight to deliver bail issues, life and liberty, dignity issues, Supreme Court.
But they are available only
utmost
to those people who can afford it. See, I mean, like you have to understand that the judiciary is available only supposing there are umpteen number of cases where a case is lost in a lower court, but because they can't afford to go to a higher court, you cannot have any. So whenever you have differences like where the lower court gives a verdict, I mean, like we have had some cases which have been happening where in one court they are set free and in the other court then they are convicted or convicted in the lower court and set free in the higher court. So
Neeraj would like to answer this?
Yes.
General issue.
As far as the anxiety, mic is working, or I'm quite loud to understand the question. So your first question is very pertinent because it takes us from victims of crime to victims of abuse of power, actually, that domain. And still, we lack a very robust or comprehensive mechanism to tackle the issues of victims of abuse of power in this country. Custodial crimes are very, very open, and they are not like done, like you mentioned the case of father-son duo who died. The magistracy should have acted the way it acted long back in 1985 in the case of Ram Sagar, where the judge has really come out of his court to see where the person is, whom I am going to give the custody of to the police official. So I think now it's high time for us to move from victims of crime and not completely shift, but orient ourselves to the victims of abuse of power also, where the police machinery or law enforcement agencies have been conferred with so much amount of power that they can detain any person without proper paperwork. They can get the custody, without showing the person to the court or taking the person to the court. But we need to understand about the other side of it also. I see the answer lies in bringing the technology, actually, so that the efficiency can be brought in the judicial process. So rather than opening the courts 24/7, why can't we have more technology-driven procedure whereby the process can be speedier? I give an example, like the case of bail, actually. Bail orders being passed by the court, but it takes weeks of it, being sent to the jail authorities. So the person, effectively, who has secured bail, remains in jail custody, say for a week or more than a week time. So that is one of the concerns raised by the present Chief Justice of India, that we need to bring some more technology, which takes the bail order immediately to the jail authorities, so that the liberty can be secured at the earliest. So I see that the technology can be an answer to that question, rather than opening the courts 24/7. So that's my take on
No,
this.
I understand. In fact, in the US, they have a system where any detention should be video recorded by body cams, where unless they have this, then the detention is not considered as a proper, this
Yes,
person
exactly.
has the liberty to be set free. But I'm saying even that can be implemented. But when we have a place where there are so many pendency of law, cases, we have the court cases which are pending when they are so huge. Some people may say that we would be willing to come even in the night to appear and get the case cleared. In fact, I'm not talking about criminal cases alone. Criminal cases are separate. There are civil cases which keep running for, decades, or even, sometimes even for a bit, 40, 50 years, and we never see that. So I was just thinking, and also online, now that during the pandemic, we have seen the system where online we have had this thing. In fact, if you can increase the number of things, then the number of cases also can come. Maybe this is not appropriate for this topic, but just a thought.
Thank you. Thank you.
Just to add one more thing about it, like we can look for more diversion of cases also, like the way we can, because many of the cases are lingering for so long, though the parties are willing to compromise, but because they are not legislatively put in that domain of being compromised, so the parties are also confused what to do with the case. So I think if we promote more and more such alternative mechanisms, whereby the parties, if they are willing to withdraw the case, just like the state can withdraw the case at any point of time. So I think that can also help the parties to settle the cases outside the court without any influence, without any coercion, just to add caveat to it. And secondly, it will also take away the case from the board of the court actually. So that may lead to another way of speedier justice.
Yeah. And probably the other thing is, I've seen in Tamil Nadu, I'm from Tamil Nadu, so many cases when they are being brought to court, you are given a date for hearing, and on the day when they go there, they just say pass over. You wait there for hours together, and the judge comes and says pass over and sets it off for another after 2 months or something like that. So is there any accountability for these kind of, if you have a case and the judges are hearing it, are there any accountability clauses in their work if that can be brought in or something like that?
I think it's changing. It's changing, and now with the e-courts mechanism, and the Supreme Court orienting the judges, particularly the speedy disposal, introducing the alternative dispute resolution, mediation, arbitration, and also in the criminal justice, lokadalas, in the criminal justice system, I think there's a need, principle of diversion we have not followed. Only essential cases should be dealt by the higher courts, and filtering mechanism should be available. So that is the principle of diversion is a very important, and also how do we strengthen the plea bargaining system. The American plea bargaining system we have introduced but still is not effective. Similarly, compounding of offenses, which is not necessary. There is a need to re-examine the compounding offenses with the permission of the court, without the permission of the court. I think these are all the several issues which are necessary, and also there should be a coordination between several agencies of the criminal justice system. Community sentencing has to be focused much more effectively. I think these are all the issues in the criminal justice reforms hopefully will be taken care in the future. Thank you. Sure.
You just said that mediation and out-of-court settlement will be a mode of speedier justice. But my only point is, will that the criminal act will be justified? Somebody, because of rash driving, kills 4 persons on the roadside, and he pays money, and out-of-court settlement they want to withdraw. But will the provisions of the criminal act be justified, sir?
I'll just, before he answer, this is a emerging principle all over the world, what we call as a tartification of criminal law. Means compensation is emerging. As he said, there's a United Nations guidelines which says not only compensation, restitution, rehabilitation should be taken for. I agree with you that there is no substitution for punishment. But at the same time, what are the other alternative ways of punishment? And how we could use the different forms of compensation has emerged. All over the world they are saying that no punishment. Can you think about punishment should be limited only to the essential, which are more gruesome acts. But don't punish. Can you think about other forms? If a privileged class criminal has conducted something, seize their assets. Invent something else, not punishment. This is what all over the world we call as a tortification of criminal. Everybody. Look at Companies Act. Companies Act is seriously removing decriminalization. Yes. Yes, sir.
When I made that statement, I was aware of this fact that I'm not talking about the cases which are serious in nature and really affecting the interests of state and the society at large. But I give you another example of a case under the POXO Act, where the girl and boy between the age of 16 and 18, they end up entering into a sexual relation, consensual sexual relation. But because there is an act which punishes that boy, so now the cases are landing in High Court and Supreme Court, and the Supreme Court is also not giving relief to the parties. Now the girl going to be the mother of the child, and he is the father, but he is languishing in jail. So I'm talking about those such cases which are hard cases. I must call them hard cases, where the judiciary should step in and see what is the most viable solution in this case. Whether the trial is going to serve any justice or a diversion at the earliest stage will lead to a peaceful society.
That is what we started, the contradiction in the criminal law, striking a balance. Absolutely. Absolutely. More and more.
I would prefer. See,
sure.
If I am a criminal, if I am doing something wrong, you attach my case, and I have a child who is 5 years old or something like that. How is it legal for you to deprive the family? In fact, when you say talk about criminals, you also have to understand the family. So, if supposing there is a
50% of the attachment, maybe 50%.
It depends upon the facts and circumstances. Yes. If there is no punishment is required, so there is a various. No, we need to innovatively think about old system of punishment. Will not.
Rehabilitation in either way, sir.
We need to think about new alternative methods. That's what always we say, that think out of box something. Yeah.
So now the POXO Act, it's going to be something where now we have brought in another act where 21 is the legal age for marriage. So is it going to become like anyone below the age of 21, if they have any kind of issue, they will be taken to task? I mean, like, these are questions. I mean, like,
of course, because the law should be taken, I think, given a holistic approach. You can't change one law and leave the other law unchanged, because both work together. Yeah. If the age of marriage is being increased, so you have to consider this particular act also, because there is a conflict. And not only that, you have a conflict in POXO Act and 375, where there is a difference of age of a child, of a girl giving consent is 16 in case of Indian Penal Code 375, but under the POXO you have made it 18 years. Yeah. Though the Supreme Court Justice Lokur in independent thought case has brought that on par with POXO Act. But yes, but most precisely what we have to see, that anything starts with the very act of legislature by defining any conduct as crime. The moment you define any conduct as crime, it continues throughout the system. It just doesn't end there. It starts from there. So X conduct is defined as crime, the entire machinery will work in that direction. The police will get the power to arrest because it's a cognizable offense. Then they will file a report, investigation will take time. So while defining any conduct as crime, the legislature also be very, very cautious that whether that conduct really poses any threat to the society or not. And then only that should be made, that conduct be made criminal. Secondly, what are the other alternatives as far as the punishment part is concerned? Like community sentence, we should be ready for that because now we have really got a system full of strength and mechanisms in place, so we should go for that, at least on trial basis for few offences, less than 3 years. Let's start with that, community sentence. Let's see how it works, because that is another way of decongestion of the prisons also. 70% population are under trials. Why they are languishing in jail? Because they are not given proper legal aid to secure the bail, they are not aware, they are from downtrodden part of the society, they are marginalized, no one is going to take care of them, jail authorities are not at all considered about their well-being, even the families, because either they don't have families or even the families are not concerned about them. So I think all in all we have to see that first, what conduct to be defined as crime should be, I think thought about, and secondly, what are the changes which are required to bring, again, when we say speedy disposal, we are not going to compromise on the fair trial compliance. That should be there at every cost.
Sir, on the same subject, good morning. First of all, I thank to Pride for organizing such a nice program. Sir, I was a student of LLB, then I went through some number of cases one of the cases, still just in case I remember, that so many persons have been punished by the concerned authority and they are undergoing jail. But even prescribed limit of jail, still they are undergoing jail. So Supreme Court on one of the case filed by NGO, that was the committee was set up and they inquired all the jails where the person are even spending time after expiry of the period of punishment. Then thousands of persons they were released after conducting inquiry by the Supreme Court. My issue that whether the government or Supreme Court set up a committee, each and every year they should go and conduct a study in the jail. The person who was undergoing even after completion of the punishment, or because of the reason, technical reason, process reason, or some they are not able to give bail or taking bail, or they have no money to security. Such cases should be examined by the government or at the level of Supreme Court committee being set up by the government or Supreme Court. So do you think it will give the delivery of justice to the poor? And
just give you a quick example of a very fine case of 2014 by Justice Madan B. Lokur, Bhim Singh case. Now, what direction has been passed, I tell you, and you say that how, as a judicial functionary, magistrate should act, and what difference that direction has made. Now, in that case, the Supreme Court came to know that though there is a provision of 436A in CRPC, which allows every person who has served half of the punishment for that offence in jail immediately be released from jail. But there are several cases, laying in different states, and majorly in UP, MP, Rajasthan, these states. So Justice Lokur passed a direction that now it is a duty of the magistrate to go to jail once in a week and find out how many cases are pending of this nature and give bail then and there. Now, whether there was required of any such direction from the Supreme Court to the magistrate. Now, it is a duty of the magistrate as a constitutional court in this country.
Sir, even sir, the judicial authority who are supervising the matter, they should also be and record and they should produce before the magistrate. Magistrate is so many work. One magistrate is daily hearing 70 to 75 cases per day. It's not possible for magistrate to go and study and see what is the condition going in the jail. Jail authority must conduct a proper review or supervision, and they should submit a report to the DM.
Delhi, yes, sir. Delhi High Court used to have regular jail adalat on Saturday, Sunday they used to do, and in addition to this, also what is necessary is technology, connecting the prison, courtroom and all together. So that will be, once we do that, who are the under trials? If 436A already is there, how many have completed half of the sentence? What is the reason for not releasing them? So this technology is one of the solution. If we connect court with prison and others, that is one effective mechanism also. But ultimately, judiciary is doing a commendable role in majority of these issues.
But ultimately, the common person, poor person is sufferer of this because of inactiveness of anyone, but judiciary or for jail authority.
Sure.
Sir, one second question, my sir, that you see the number of institutions in the court, Supreme Court, High Court, institutions are very less as compared to cases pending in the court. Course of cases pending all over India.
Yes.
So I think we should increase the set of the judges and then institution of the justice, so that the people are not going to court due to money. Some people, they have money, but they see long pending cases. If in case of file case, they get justice 15, 20 years.
Yes.
The people are not preferring to go for justice, even they are bearing injustice.
Yes.
So that should be one of the way to just increase the delivery of justice. That's my suggestion. One more thing, sir. This is criminal cases. We see this compounded case or non-compounded case. I heard one case the Supreme Court gave a bail to made the case compoundable where the victim was rape victim, a lady. The case was going on under trial, and even though Supreme Court allowed the person for the compromise of the case. I think the criminal case should not be allowed. Criminal case against the state, not the individual person. They not compounded as per my information concern. I'm even a law student. But Supreme Court allowed this particular party to come and compromise on the rape cases. Do you think it's justifiable? What is your opinion?
Generally, in the serious offences,
and it should not be.
Generally, they don't
there is a
use.
trend also in Supreme Court that,
Yeah.
because see, if we can...
But in civil matter, I don't understand. It is compoundable.
Yeah.
But in criminal matter, heinous crime, and in case somebody allowed to... I don't think it is...
Such cases, because filing cases is so easy in this country. Anyone can file case against anyone at any point of time. So sometimes in the haste of the moment, may the woman file the case against the person, and subsequently they marry also. So now, what justice demands? Again, I'm taking back to saying, like, victim should be given a say in those matters, because though, of course, offense in its very nature falls in the domain of serious and heinous offense and posing a threat to the society at large. But when it's brought to the very specific case, should the victim be given a say in that see, we have entered into a compromise, so should this case be allowed to continue, or I be given chance to start my family with the person? So I think there is always this contradiction. And of course, many a times courts have really appreciated that the state's interest in pursuing the case should be
I
allowed.
got your point, but issue is that in case a victim is poor, then is not able to survive because of certain reason he may come for compromise. But in case the victim is
Of course,
powerful,
I agree with you
then,
on this point that
obviously
might or
nobody
money,
will come forward for compromise.
might or money should not be the reason for such
Intention
compromise.
is more important. If it is intentional, then
Yes, yes.
Okay, thank you. And now I request honorable members or other participants, those who have joined online, if they have any questions. So if there are no questions, then I think we will conclude the session. And now I will request, thank you so much for joining and acceding to our request. Now I will request Shri Prasanjit Singh ji to present a memento to Professor Rao on behalf